Welcome to Impact Makers Radio, helping you to find jargon-free information before choosing a professional to help solve your problems and live the life you love. And here's your host, Stewart Andrew Alexander.
Hi and welcome to another Let's Talk Bankruptcy conversation. And on this segment of the show, ladies and gentlemen, I'm very pleased to say that we have investment manager and legal counsel David Kerstein of Bentham IMF, all the way from Manhattan, New York. Now, David, who has a wealth of experience in the area of bankruptcy, and I'm sure he will allude to his additional experiences quite shortly, will be talking to you today about a very interesting topic. You see, David is here today to talk about utilizing litigation finance in bankruptcy. So, if you are one of the, let's say, increasing numbers of people in the Manhattan, New York area, and you, feel that today's topic may be of relevance to your own situation, then you may just want to, whatever you're doing right now, just take a break, down tools, log out of Facebook or Twitter or anything else you happen to be doing which may cause a distraction. And you might even want to grab a notepad and pen and get ready to take some notes as we listen in to what David has to share with us today. So with that said, let's not keep him waiting a moment longer. Welcome to the show, David.
Thank you for having me, Stewart.
You are so welcome, David. So it goes without saying, just before we get started, it goes without saying that anything you share with us today is not legal advice or legal assistance. It's purely for the purpose of sharing information. Now, would you just care to expand on that in your own words so that everybody is really clear about what we're doing today, David?
Sure. While I used to be a practicing lawyer, I no longer am, and anything I say here is in the context of explaining litigation finance and how it can be used, but is not legal advice and shouldn't be taken as such.
Okay, that said then, Davis, tell us a little bit about your company, the people who you serve, and the kinds of situations they find themselves in when they come to you for your help.
Sure. So Bentham is a leader and really the pioneer in commercial litigation finance. The company was founded over 17 years ago in Australia, actually, and is now publicly traded on the ASX, the Australian Stock Exchange, and since we've been around so long, we've been able to look at and invest in and complete more investments really than any of the other funders out there, over 220 completed investments to date. Beginning in about 2011, Bentham branched out to the rest of the world, opened an office here in New York. We now have four offices in this country. I'm located in New York, as you mentioned. We have offices in Canada, the UK, Singapore, Hong Kong, as well as our original 5 in Australia. So we really provide funding all over the world, all over this country, internationally and transnationally as well. We're seeing increasing opportunities, what we call offshore as well, in the Caribbean area. We provide capital to businesses of all sizes, to litigation and liquidation trusts, to receivers, to bankruptcy lawyers, and all of our funding is done on a non-recourse basis. And I'll come back to that in a moment, in order to pay for some or all of the legal fees and costs in very expensive commercial litigations, or even to provide working capital to small businesses, or to pay for the expenses of a trust. And we invest in cases really where the damages are starting at or north of $10 million. And our funding can really help lawyers who want to take on more risk, or whose clients are asking them to take on risk, but who can't do that, and so they can share that risk with us. And it can help clients, trusts who want to hire better lawyers who maybe can't afford them, to be able to use our capital to do that.
Okay, David, when you think about those companies that you work with on a day-to-day basis, those lawyers, those litigation and receival trusts, what are the advantages of utilizing litigation finance in bankruptcy?
So I'll back up a second just to sort of explain a little bit of the background of litigation finance. So first off, some sort of nomenclature. Sometimes you'll hear it discussed or called litigation funding. Sometimes you'll hear it called litigation finance. They're really interchangeable. And it really means any transaction where the asset value of a litigation claim is used to secure financing from an outside party. And the funds in commercial litigation are almost always provided on, as I mentioned before, a non-recourse basis, which means that the return of capital to the funder is going to be tied only to a successful outcome in the litigation. We only get a return in the case if the case succeeds, if there's a settlement or a judgment that's collected. And so part of the reason why it's become so incredibly popular and increasing in usage around the world is in large part because of how incredibly expensive the legal system is in general. There's a general, in this country at least, dissatisfaction with the hourly billing model that had been traditionally used. There's a lot of budget uncertainty. Budgets are often blown and run out, and cases cost a lot more than clients had been told they were going to cost. Legal expenses, even for large companies, have to get expensed on corporate balance sheets, and litigation is a risky endeavor. And so there's a need for risk mitigation and risk sharing, and that's where litigation funding can come in. It can really help to facilitate the recovery of lost revenue for a business, to access capital from meritorious claims, to enable the risk sharing that I mentioned before, and to reduce budget uncertainty for companies and for law firms, and really provide the resources to allow trusts or corporations, fiduciaries, to hire the best counsel they can, and therefore be able to realize the best value out of their litigation assets. Oftentimes in bankruptcy, a litigation trust will be set up, but it won't be really properly or fully capitalized, and that trust might have claims, but absent the amount of capital that's needed to really litigate those claims for the highest value, the trustee ends up having to settle the matter for pennies on the dollar of what it's really worth, or the trustee gets drowned in paper by their more well-capitalized adversary, and the case gets decided based on that imbalance of resources and who has the deeper pocket rather than who really has the better claim. So that's where litigation finance can come in, and a trustee, for example, can use a funder to access capital and be able to take that claim out to where its full value is before it has to be resolved, or take it all the way through trial and appeal if necessary.
Well, that's a great answer, David. So thanks for sharing that. I'm sure that's going to be really useful for our listeners out there. So with that in mind, what you just shared with us, what do you feel are some of the biggest myths out there when it comes to utilizing litigation finance in bankruptcy?
So I'd say one of the myths is that when you have a litigation funding arrangement, or if you're going to enter into one, that arrangement always has to be presented to and sort of approved or blessed by the court that's overseeing the action. That is the case in some circumstances, and it sort of depends where the litigation funder comes into the equation. If it's before a trust is set up, oftentimes you will have to disclose to the court that you're going to be using litigation funding, and have the court look at the contract and what the terms would be, and give its approval to that. But oftentimes, after a trust has been set up, it's been given the proper authority, and if it's been given the proper authority, it can go ahead and enter into financing agreements, and just like it can enter into other types of agreements, that if it's given the approval by the court to do so in advance. I'd say the second biggest myth is there's an ancient doctrine that's been around for a long time that originated in medieval times, really, in England, called champerty and maintenance. And that is a doctrine that came about because back in those times, lords and barons and princes were using their wealth and their power to basically abuse the judicial system and use their serfs and peasants as proxies for their own disputes, or to gain advantages and gain additional wealth. And so rules were enacted that said third parties cannot get involved in supporting litigants who are involved in litigation. Those doctrines survived and migrated over to this country and to other countries that were thereafter colonized. And people have heard of these doctrines. They've been around and think that they still will bar third parties from like litigation funders from coming in and supporting a litigation. And you have to be careful. In some jurisdictions that is still true, but in many jurisdictions those rules have been done away with, where they've been interpreted in such a way as to allow funding in the manner that I described before, where it's non-recourse, and also where a funder doesn't take control of the action. It's now allowed to happen. And indeed, in Hong Kong and Singapore, for example, they just changed their rules to allow for litigation funding to be used in international arbitrations and in insolvency cases.
So, David, I can imagine if I am a business owner and I'm considering my options for litigation or using litigation finance in bankruptcy, that I'd go out online, I'd speak with other business owners, I'd speak with other people that may have been in the same or similar situation to the one I find myself in now, to try and get somewhat of a picture of how things look within or throughout the whole industry. And in doing so, I may come across information that's not entirely accurate. So my question to you then, David, is what are one or two common misconceptions around your industry?
I think especially amongst larger institutions, insurance companies, for example, and some really larger businesses, there are a couple of misconceptions. One is that litigation finance is kind of an evil thing, that all it really does is it's outside financiers gambling and encouraging frivolous litigation. And the reason that's incorrect is if you step back for a moment and really think about the business model that I described before. Commercial litigation funders, their investments are all structured as non-recourse investments. We only get a return if the case is successful. And so we really have no incentive to invest in a frivolous litigation. And in fact, we do, certainly at my company and most other reputable commercial funders, do really heavy due diligence on the matters that we're considering investing in. We kick the tires on them really carefully, and we're really trying to only invest in cases that we think are likely to be successful. Do we get it wrong sometimes? Sure. I mean, we've been fortunate. We've been able to return funds in about 90% of the cases we've invested in, so we have a really good track record. But you get it wrong sometimes. But the notion that we encourage frivolous litigation and that the industry is therefore kind of an evil thing that just ratchets up costs in the judicial system is really the furthest thing from the truth. I'd say the second misconception is that litigation funding really only benefits the little guy, and therefore big entities should naturally be opposed to it because it's only for the little guys and it's only helping them. And sure, we do help a lot of small and mid-sized companies and individuals with large claims and help them access capital and help them level the playing field against the big guys. So that is true. But funding can really also be beneficial for larger institutions as well that are really well capitalized and could afford to fund a litigation themselves if they wanted to. But instead, they could use our capital and preserve their capital to go make the widgets that they're used to making, and not to use it in sort of affirmative litigation that they're not used to engaging in. And secondly, as I alluded to before, even a big institution, when it's engaging in a litigation and it's spending a lot of money on it, it might have those funds, but it has to expense them on their balance sheet. And it could really hit their P&L or hit a division within the company's P&L and affect their profits, affect their share price if they're a public company. But they can instead use litigation funding and basically take that expensive litigation spend off their balance sheet. And so it could really be beneficial for them as well.
So, David, when you think about your clients, what are some of their most common fears about utilizing litigation finance?
I think two of the most common fears that we hear about are control, and then the issue of what can be disclosed to the funder and whether disclosure of information might waive any privilege or confidentiality that attaches to those documents. So taking those in turn, on the control point, clients and lawyers are very concerned about having a third party come in and get in the middle of their relationship and affect the decisions that they're making in the case, and that lawyers have fiduciary duties to their client to make. But the reason why that's not an issue, at least again, I think for my company, for Bentham, for most reputable funders in this country, we don't take control over any litigation that we invest in. When we invest in a case, the major rights that we have really are the right to be paid the return that we contracted for, the right to be kept informed of what's going on in the case on a regular basis, kind of like a defense counsel would do with an insurance company. And secondly, the right to be the right to be appraised of what's going on with settlement and be allowed to weigh in with our views. But ultimately, those decisions get left between the lawyer and the client. And so we intentionally do not take any control over litigation, because if we did, it might run us into some of those problems that I mentioned before with respect to running up against rules regarding chamber and maintenance. It might run us up into rules in some jurisdictions concerning usury restrictions. And so we intentionally try to stay far away from the line of control. On the disclosure point, as I mentioned before, we diligence the cases that we're looking to invest in very carefully. So it is really important for us to get a lot of information from the lawyers and from the claimants in the cases where we're being asked to potentially commit funds. But if you structure it properly, the information that is provided to us should be protected, at least in this country, which is really the rules I can speak to most affirmatively. There's a doctrine. There are two important doctrines. There's the attorney-client privilege, and then there's the work product doctrine, which generally protect the disclosure of materials that are exchanged between lawyers and clients in a litigation from being disclosed to their adversary. When you disclose those kind of documents, and when they're protected by this privilege to a third party, there is the potential for waiver. With respect to attorney-client privilege material, we intentionally don't ask for that kind of material. We don't want to get it. We don't think we need it for our analysis. If we get it by mistake, we'll return it or destroy it. Work product is different. It is important for us to see work product, to see what the lawyers are thinking about the case. And the weight of the law in this country and in most jurisdictions, and really the growing body of law, is that if you have the right protections in place, lawyers can share material that is protected by the work product privilege with a third party, and it doesn't cause a waiver of that privilege, and it won't have to be disclosed to your adversary as long as you have the right protections in place, such as having a robust non-disclosure agreement. And so at Bentham, at least, before we get any sensitive information, before we dig into the details of any case, we always insist on having a robust NDA put in place and signed by the parties.
Right, so you've got into quite a lot of detail explaining those fears, those common fears that your clients have. So with that said, David, how can they actually get past those fears? What do you recommend for that?
The first thing to do is really to do some investigation of the funders that you might be engaging with and considering using. It's really important to look at a funder's track record and their reputation, and you can investigate whether they've been involved in any litigation. We're fortunate here. We have never been involved in a litigation. We've never been sued or have sued another party. We have a great track record that is all on our website, and we're a public company, so we publicize all our results, and we have a really good reputation, and we think that's really important. There are many new entrants coming into this space every day because of it's been publicized in the news quite a bit, and the returns have been advertised as very strong. The returns are non-correlated to the rest of the market, and so there's a lot of people and entities coming into this space and doing, or at least dabbling on a one-off basis and potentially funding cases. And it's possible that some of those entities don't really care about the long-term health of the industry and don't really care as much about sort of ethics and making sure that they follow the rules. And so it's important that for parties and lawyers to investigate who they might be getting into a relationship with. And secondly, as I alluded to before, once you get into that relationship and you start disclosing materials or considering disclosing materials, it's really important to make sure that you have the right protections in place, that you have an NDA in place, that you're careful about how you exchange material, who transmit what to whom. And if you have the right protections in place, you can really protect the material and avoid the issue of waiver.
So, David, what other perceived obstacles are they that might be preventing your clients, those lawyers, those litigation and receival trusts, from seeking the help of an investment manager and legal counsel like yourself? Sure.
So to step back a little bit and give a little bit of a history of the industry to answer that question, as I alluded to earlier, that the industry really started in Australia with my company about 17 or 18 years ago. It kind of migrated to the international arbitration sphere and then to the UK, where it's been adopted and is fairly well utilized. And it eventually came over to this country, to the US, around the time of the financial crisis with any real prevalence, and has really picked up in the last 5 or 6 years. Once it started picking up, it kind of got adopted by big law as well as the smaller litigation shops and clients that had been utilizing it. And it initially gained some prevalence in the IP space. So there's a lot of patent litigations that have been funded for a long time, and eventually migrated over to the commercial litigation space. But for some reason, and I'm not sure why, it kind of skipped over the bankruptcy and insolvency world, even though it can be really useful there, and capital's at a premium. And as explained before, there can be some really good benefits to bankruptcy professionals and practitioners and corporations and clients involved in that space. And so, to me, it's really a matter of publicizing and marketing what the products are that are available to bankruptcy professionals. And once most folks have heard about the products and heard how it could help them, most folks realize how useful it can be.
So as a reminder, ladies and gentlemen, my guest today is David Kerstein, investment manager and legal counsel at Bentham IMF, and is here today talking about utilizing litigation finance in bankruptcy. Now, with that in mind, David, and for those lawyers and litigation and receival trusts that are listening in right now, what are some of the little known pitfalls, or let's say common mistakes, that they need to keep in mind no matter what kind of situation they find themselves in?
One of them is to be careful about the champerty point that I made before. In some jurisdictions, champerty is still a live theory that would bar outside parties from supporting a litigant with capital or otherwise in a litigation. And so you do have to do your research and make sure that you're in a jurisdiction that permits you to do that. Secondly, attorneys do have duties of confidentiality, and so they need to be careful about what they share with a funder, absent getting permission from their client to do so. Attorneys also need to, and clients also need to be careful about waiver of privilege, as we mentioned before. And finally, on a more practical level, parties that are considering funding really need to be careful about who the funder is that they choose to get into an arrangement with. There sometimes is, of course, an instinct to go with the funder who might offer the best price. It is, at the end of the day, money that's being offered, and price and return is certainly important. But there are other intangibles that are important as well that clients and lawyers need to think carefully about, including who it is that you're going to be getting into a business relationship, what type of reputation and track record and capital does that party have.
So, David, in terms of those pitfalls that you just shared with us, how could they be avoided? What can one do to avoid those mistakes?
Research, and investigation. There is a good body of information out there now on who the funders are in the space. My company, for example, has a website that we'll give you at the end of this program, I believe, where all of our history and track record is out there for you to see. On the ethical issues, it's fairly easy to research which states in this country permit funding and which don't. We keep pretty close track of that, so people can always reach out to us as a resource for that information. And with respect to waivers, having a robust NDA in place is critical.
So, David, I've interviewed hundreds of professionals throughout my career, and I've yet to speak with anybody that followed a straight path from where they started to where they are today. So, with that in mind, David, what inspired you to become an investment manager and legal counsel? How did you end up here to where you are today?
Sure. Yeah, I think it's somewhat interesting. I was a litigator for 15 years, and I actually spent 14 of those years at the same litigation shop, litigation department of Gibson, Dunn & Crutcher here in New York, a very well-known litigation group. And I actually was kind of on a straight and narrow path for a long time, kind of doing the same thing. And at a certain point in time, I did get the idea that I thought I wanted to do something different. I never wanted to leave Gibson Dunn. It's a great law firm. I didn't want to go to a different firm, but I did think that I wanted to do something else more on the business finance side, but I wasn't really sure what that was. I was a general commercial litigator, and there didn't seem to be a ton of interesting opportunities for general commercial litigators if you didn't have a niche. It was sort of hard. And one day, back in 2011, I was working on a case that involved a big fraud that had taken place against Chevron in Ecuador. And in the course of that litigation, we discovered, as we were helping the client uncover the fraud, we discovered that the plaintiffs in that case were actually being funded by one of Bentham's now competitors. And now the industry is still relatively nascent now, but it was really nascent back in 2011. And so that was the first time I'd ever heard that litigation funding or litigation finance was even a thing. And literally kind of the cliched cartoon light bulb went off in my head that, wow, that's a great way to sort of utilize my litigation skills in more of a business and finance role. And I started to research the industry pretty heavily after that and made the jump over to Bentham in November of 2014, so about 3.5 years ago.
So, David, can you share a lesson that you learned early on that still impacts how you do business today?
Sure. So when I first joined the company, we were contacted by a potential client, by a company who was interested in our services, and they didn't provide that much information up front, and you couldn't really tell if it was that interesting of an opportunity from the initial contact. But we jumped on it really quickly, and we were really responsive, and we met with them in person right away. It turned out to be a fairly interesting opportunity. And as we spoke with them while we were considering whether we might want to make the investment, and when they were considering whether they might want to use us or go with another funder, we sat with them for hours and brainstormed how we could even improve the claim that they were considering bringing. And we actually, in the course of that process, uncovered some pitfalls in the strategy that they had originally been contemplating pursuing, and we were able to help them basically fill in those holes that had arisen. And so we sort of found out that, first off, being sort of very responsive, being agile, and being willing to help in more than just providing capital, but in order to brainstorm and think through questions and really be sort of a value add in addition to the capital was really helpful. We here at Bentham are all former litigators. All the investment managers have 15 years or more of litigation experience. And so really approach things from a litigation perspective, and we're able to add that added value on top of the capital we provide to clients. And that's always been really helpful to the clients that we serve. So responsiveness, being agile, and being able to sort of add value has been really helpful. And also just really being upfront and honest and ethical. We really try to think of ourselves as the ethical funders has really helped us win a lot of business, frankly, in that in certain deals we've had to tell clients, right off the bat, it's not a deal for us and sort of walk away, whereas some people will tend to string out their clients and keep them around longer. We have really no interest in doing that. We'd rather, if that particular deal is not one for us, let the client go out and find someone else who it is the right deal for them. And oftentimes that has served to win us new business in the future when the right deal does come around.
So, David, you've shared a lot of great information so far. So I just really want to take the opportunity out just to thank you for that before we move on to our next question, because I'm sure that, you've shared a lot of great insights that I'm sure the listeners are going to find very valuable. So with that said then, David, what's the most important question that your clients should ask themselves as they consider utilizing litigation finance in bankruptcy?
Sure. I'm going to give you kind of a three-part answer. I think clients should be asking themselves, do I have enough capital to get my claim to its highest and best value? Do I have the right professionals involved to help really maximize the value of that claim? And are those professionals incented in the best possible way to get the claim across the goal line?
Right. So before we close out with our last question for today, what's the most important thing that the lawyers, litigation and receivable trust people who you work with should consider when evaluating an investment manager and legal counsel like yourself then, David?
Track record. Look at what your funder's track record is and look at whether your funder is focused on ethics and fairness.
Yeah, I guess that's really important. It's just not to jump feet first in and take the time, have the patience to do your research, right?
Exactly.
Fantastic. So if there is somebody who feels they want to know more about utilizing litigation finance in bankruptcy, how can they find out more? What's the easiest way to connect with you, David?
Sure. Please get in touch with us if you have any questions. You can reach me on my direct line at 347-767-2059. You can shoot me an email at dkerstein@benthamimf.com, or you can go to our website at benthamimf.com.
I just want to just clear something up because, like I alluded to before, you've shared a lot of great information today, David. And even though our discussion has been of a lot of value for the listener, there may be somebody out there who's still kind of sat on the fence. They want to get in touch. They may want to pick up the phone and give you a call. However, they're a little hesitant about what's going to happen once they make that call. So could you just briefly explain, walk them through exactly what will happen if they do decide to pick up the phone and give your company a call?
Sure. So the way our process works is when someone reaches out to us, we generally do a very initial high-level intake call of what they're calling about. If it's an opportunity for us, we'll do a very high level without getting into any of the names of the parties or any confidential information to see if it generally is something that hits our parameters. And if it is, we will then ask the client or the law firm on behalf of the client to sign up an NDA to protect our communications going forward. Once we have that signed NDA, we'll do a little bit of a deeper dive into what the case is about, find out the name of the parties. We'll run a conflicts check to make sure we don't have any conflicts, and we'll find out some general information about the case, generally what the potential value of it is, what the type of claim is, what jurisdiction the case is pending or contemplated to be brought, who the lawyers involved on both sides of the equation are, and maybe look at some key documents that explain what the matter is about and what the various risk factors are in it. And then generally, after we've had a chance to take a look at that information, we'll also want to talk to the client, and preferably meet the client in person, talk to the lawyers, and get their understanding of the case. And generally, within about a week or two of having done all that, we can decide if it's something we want to move forward with or not. And if we do want to move forward, we'll propose a term sheet to the client or the lawyers that sets forth the material financial terms that we would go forward on. The term sheet's non-binding, except for if we do reach agreement on the terms, we ask for a period of exclusivity, usually between 30 to 45 days, and that's where we do our heavy due diligence, our heavy kicking the tires, and we spend a lot of time and effort and sometimes money out of our own pocket to diligence the cases, and that's the reason for the exclusivity, because we want to make sure the transaction's available for us at the conclusion of that period. And if the diligence checks out, if we then would negotiate a final funding agreement with the client. If we can reach agreement on the final funding agreement, if the diligence checks out, we take the matter to our investment committee for final approval to enter into the deal. And if they approve, we then add our signature to the dotted line, and we're off and running with the funding.
So you're not going to take them around the back of the office and hit them over the head with a Fred Flintstone club and drag them rather by the hair. It all sounds pretty...
We try not to.
Yeah, it all sounds pretty civil to me. So, David, unfortunately, we have come to the end of the show. I feel that we're just beginning to scratch the tip of the iceberg with the amount of insights that you could share. However, we do have to go. So let me just remind everybody, we have been listening to investment manager and legal counsel David Kerstein of Bentham IMF in Manhattan, New York. Thank you so much for sharing so generously with us today, David. You have certainly demonstrated that you are a true educator, advocate, and trustworthy advisor for your client's success. So thank you.
Thank you, Stewart.
You are so welcome, my friend. And I'd also like to take a quick moment to say a big thank you to you. Yes, our listener. You're out there in the Manhattan, New York area. Maybe you are a business owner and you're considering your options for bankruptcy. Well, thank you for taking the time out of your busy day to come and join us on what I can only describe as a very insightful and informative discussion with one of the leading investment managers and legal counsels in Manhattan, New York today. Again, his name is David Kerstein. Make sure you do check him out. Give him a call, send him an email, visit his website. There are some great resources on there. Whatever you do decide to do after listening to David today, I'm sure that you'll most certainly be in good hands. So that's it for today again, folks. My name is Stewart Andrew Alexander, and we'll be back shortly with some more leading bankruptcy professionals in this, our series of Let's Talk Bankruptcy Conversations. So until then, take care, have a great day, and we'll talk real soon.
Thank you for tuning in to Impact Makers Radio. To listen to all past, present, and future industry thought leaders and trendsetters, visit us at impactmakersradio.com.